Because the person generalizing them is the accused. This is why it's fundamentally important that if there is to be justice in this court, then the whole question of how we are represented should be addressed before this very application can be had. Who are going to make submissions that you are ordering when everybody is on the run? So either it appears to me that the last sitting I did make a point here that Mr. Museveni should reenact the law of detention without trial. And this was advisedly, because that's what it seems all this is aimed at. That we simply remain in detention because we cannot have lawyers, we cannot, the main case we are talking about, we have never seen the disclosures because facilities are. So coming to this court, it seems we will be tried with our eyes covered, with our hands and feet tied, and with our lips zipped. How can we have justice in that case? What's going on this? As you have heard, we did not have lawyers in the process leading up to today. The respondents have not been served up to date. Therefore, they could not have even responded. And this is because of what has been going on. You have heard, that our lawyers are on the run.
Second respondent, NUP Times, is absent. Third respondent, Matt Kano, Ephraim Yawanga, was absent. Your Lordship, this application was on the basis of instructions from the applicants, 13 law firms, about 50 advocates. The joint instructions were to be executed under the leadership of Senior Counsel Karua, Counsel Lukwago, my lords, our leading counsel, not here. Senior Counsel Master Karua was reported, and he will refer Master. When he had come to prepare for the matter, mandate you tell the instructions, that's Lukwago, is abducted shortly after his struggles to serve the papers. As we stand, my Lord, we need to reassemble defense team and get further instructions. This morning we consulted our clients down in the basement, the prison cells. The court prison cells, not basement. And I strongly insist they will need their full defense team. And that said, my Lord, we went ahead and filed the SENAS application number 227, 2026. To address all matters. 248, I think about 248 of 2026. That's pending admission of the EQE system. This application, my Lord, is intended to address matters concerning the right to legal representation, security of the defense team, defense counsel, a service of court process, unhindered through alternative options of social service. That will go to address matters on non-service or the other respondents. In the process, my Lord, it is our prayer and prayer of the applicants that proceedings in 227 of 2026 be put on hold. This particular application is states. I will first address application that has been filed out for emergency 248 2026.
Coming to this point, it seems we will be tried with our eyes covered, with our hands and feet tied, and with our lips zipped. How can we have justice in that case?
I basically have already said all the concerns. If you had my ruling, it will be addressed in that matter.
In which matter? Because you are telling us to make submissions. Who will make submissions? Because please don't run away.
Very carefully listen to the submissions of both parties. the same I will go to record. I will not reproduce them. But I will go ahead and make the following remarks and findings. That on the onset, I want to state and agree with the Council of Women that this application was filed by about 13 law firms, as he has stated. This position is confirmed by the notice of motion, which was filed, this notice of motion, which was filed on the 2nd June. And at the end of this notice of motion, it is clearly stated that this application was jointly drawn and filed by those 13 law firms. Indeed, as Council has submitted, the applicants have been represented by more than 50 lawyers, but today I can say like 10 lawyers and so. However, I also agree that the applicants or the chosen persons have got the right of their choice of their own lawyer and who should and who should not lead. Because of that, I will grant this application with the following orders. 1. The applicants are given opportunity to get additional lawyers of their own choice to beef up the team of the 13 law firms, of the 50 lawyers. I'm giving them up to 2nd July to get their own lawyers. However, I go ahead and say, as I'm giving the applicants the choice to assemble this team of lawyers, they should assemble from today, and by that date, 2nd July, the same team of his choice should file written submissions in this application by 2nd July at not later than 6 p.m. So the same lawyers of his choice, in addition to the current ones. So if they do that, then the respondents should file their written submissions by 4th July. And I want to say 4th will be a Saturday, but I order that you have 5th, 4th, up to, we are now using weekends. So don't raise the issue of weekend. By 4th July at 6, file 50 lawyers, but today I can say like 10 lawyers and go. However, I also agree that the applicants or the chosen persons have got a right of their choice of their own lawyer and who should and who should not lead. Because of that, I will grant this application with the following orders. 1. The applicants are given opportunity to get additional lawyers of their own choice to beef up the team of the 13 law firms, of the 50 lawyers. I'm giving them up to 2nd July to get their own lawyers. However, I go ahead and say, as I'm giving the applicants the choice to assemble this team of lawyers, they should assemble from today, and by that date, 2nd July, the same team of his choice should file written submissions in this application by 2nd July at not later than 6 p.m. So the same lawyers of his choice, in addition to the current ones. So if they do that, then the respondents should file their written submissions by 4th July. And I want to say 4th will be a Saturday, but I order that you have 5th, 4th, up to, we are now using weekends. So don't raise the issue of weekend. By 4th July at 6, file the written submissions regular. Then, rejoinder of the team, the applicant's choice, should file their rejoinder, if any, by 6 July, but not later than 6 p.m. Then, after that, the application, which is said that was a file of which I have not seen, cannot stop this honorable court to give directions this matter which was filed before. So this application therefore will proceed on its own merit, and all the concerns from both sides should be put in their written submissions, of which those concerns in the written submissions will be addressed by this honorable court in its ruling, which will be delivered by witness and emails of the lawyers who filed this application. The ruling will be delivered on 8th July at 3 p.m. The outcome of this application will determine the main session number 335 of 2025, when the ruling is delivered on 8th at 3 p.m. I so far.
My lord, before you